You ready? Thank you. We are here on our case number 1CACV 180048, Ogden versus Digital Intelligence Systems, LLC. Counsel, as you know, both sides are allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. You may be seated. Oh, sorry. You needn't be seated. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium reflects the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if when you approach the podium, you give us your name and the name of your client for the recording. We have read the briefs. We have studied the record, and we've also discussed the case in our conference. So with that, you may proceed.
Thank you, Your Honor. Barrett Lindsay, on behalf of my client, Martin Ogden, the plaintiff and appellant in this matter. Your Honor, this case is essentially about allowing my client, Mr. Ogden, an opportunity to arbitrate all of his claims in the appropriate forum and all together. And as this court is well aware, Mr. Ogden has filed a first action in Maricopa County Superior Court, which seeks to compel the parties to arbitration to arbitrate all matters arising out of the employment agreement, including this breach of contract matter. This second action, which he also filed in Maricopa County Superior Court after the first action, he seeks to reserve his right to have a court of law decide his breach of contract matter, assuming he were to have lost the first action on the merits. This case was not intended to move forward on the merits until after the first case was resolved. And essentially, Your Honor, there are three main fundamental errors of law that were made by the Superior Court in this case. First, the Superior Court incorrectly weighed issues of fact and resolved issues of fact when it analyzed Digital Intelligence's motion to dismiss. Secondly, the Superior Court accepted jurisdiction over the second matter on the merits while the first action remained pending. And then finally, Your Honor, the Superior Court improperly awarded attorney's fees against Mr. Ogden, even though the settlement agreement between the parties clearly states that neither party would be awarded attorney's fees. Your Honor, with respect to the motion to dismiss, the standard for a 12b6 motion is well known. The court cannot resolve factual disputes. It cannot weigh evidence. It has to construe all facts favorably to the plaintiff, and it can only decide the motion to dismiss if, as a matter of law, the plaintiff is not entitled to any sort of relief under the facts as pled. Well, in this case, the court clearly weighed facts. To begin with, it didn't accept the contentions in Mr. Ogden's complaint, where he clearly alleged that Digital Intelligence did not pay him the correct amount owed under the settlement agreement. That right there would entitle him to a favorable ruling on the motion to dismiss. The court should have denied the motion.
Well, let me interject here. It's kind of an odd 12B motion, to be sure, how it was litigated. But as I understand it, Mr. Ogden, there's no dispute that the court should not have accepted the copy of the settlement agreement that Disys attached to its motion to dismiss. And Mr. Ogden didn't object further to the payment stubs, if you will, that Disys also submitted. That being said, I don't see in the record any indication that Mr. Ogden ever said, beyond what I have said in my complaint, I have more evidence.
Your Honor, respectfully, and this is an argument that Digital Intelligence has raised in their opposition on this case. It's certainly the Superior Court can consider documents intrinsic to the complaint to analyze as a matter of law whether a motion to dismiss should be granted. But what the Superior Court cannot do is rely on intrinsic documents to weigh the evidence and then to decide factual issues. It's really simply allowing the court to analyze intrinsic documents does not get rid of the 12b6 motion to dismiss standard.
Right. But I guess what I'm asking is there more to be had in the way of evidence? I mean, we'll get to whether the court improperly weighed the evidence, but I want to understand. I didn't see Mr. Ogden saying, if I'd had the chance, I had a lot more evidence to throw in here.
Your Honor, at several points in time before the Superior Court, Mr. Ogden represented to the court that he had extrinsic evidence to go to the issue of to support his interpretation of the contract to prove that he was entitled to a certain payment of $13,810, which even the amount tendered by Digital Intelligence did not meet that amount.
What evidence was that, and where did he bring it to the attention of the Superior Court?
Your Honor, in opposition to the motion to dismiss, he certainly requested essentially, Mr. Ogden pointed out to the court that Digital Intelligence's motion to dismiss was getting into the issue of contract interpretation. And Digital Intelligence has apparently taken the position that paying $13,684 has satisfied their obligations under the settlement agreement. And Mr. Ogden has said that he was entitled to a take-home payment, a net payment of $13,810. And if this issue was in dispute, he has extrinsic evidence to prove that his interpretation of the contract is correct. Additionally, in Mr. Ogden's complaint, I believe it's paragraph 13, he alleged that there was pre-settlement correspondence.
There's an email.
There's an email that was dated before the parties entered into the settlement agreement, where Digital Intelligence, a representative from their company, agreed to settle the claim for $13,810.
What evidence other than that email did Mr. Ogden tell the Superior Court he wanted to bring up?
Your Honor, evidence would be the wrong word. It would be within the record where he had in opposing the motion to dismiss and filing the motion for reconsideration, and then in the reply to both motions for reconsideration, he requested an opportunity to present extrinsic evidence that goes to the issue of contract interpretation at the appropriate time. He certainly preserved that argument, and this entire issue further demonstrates why it was improper for the Superior Court to enter judgment as a matter of law, because this issue of contract interpretation and resolving an apparent conflicting interpretation that Mr. Ogden has assigned to the contract and what Digital Intelligence has assigned to the contract has remained unanswered. And I would further note that when a contract term appears to be ambiguous, or where each side appears to have a different interpretation as to what a contract means, it's the Superior Court's job to analyze this issue, to weigh all extrinsic evidence that goes to this issue of contract interpretation.
But what if the terms are not ambiguous?
Your Honor, the initial determination is a matter of law for a Superior Court to determine whether the terms are ambiguous or not ambiguous. However, the Arizona Supreme Court opinion, Taylor v. State Farm, has made clear that a court cannot simply decide, standing on its own, the contract terms are unambiguous. It should wait and hear the extrinsic evidence to see if this certain evidence makes the contract interpretation reasonably susceptible to what a party is saying. And in this case, based on Mr. Ogden's contention in the complaint itself about that email correspondence dated before the settlement agreement, there's a reasonableness to his understanding that the parties intended to settle for a take-home payment of $13,810, which the record demonstrates he did not receive. And if the contract is reasonably susceptible to two different interpretations, the contract interpretation matter is no longer an issue of law. It's an issue of fact for the jury to resolve.
But it's funny because the contract doesn't mention the other payment. So how can a contract that doesn't mention another payment be reasonable to interpretation to include the other payment?
Your Honor, in my review of the contract, it's clear that this take-home payment that Mr. Ogden was to receive, it's an implied term of the contract, because the contract states a gross amount, which I believe was $16,296, to be made in two different payments that add up to less than that total amount that's set forth in the contract. There's payroll deductions that are going to be deducted from the W-2 payment. So even within the terms of the contract itself, it's clear that as a take-home payment, Mr. Ogden was going to receive less than what is facially set forth in the contract. And so clearly there is an implicit or implied term in the contract, which is, after all is said and done, after the payments are made, how much was Mr. Ogden entitled to receive. And I would also add, if all is said and done and it turns out that, digital intelligence is able to prove that making the two payments did satisfy the contract, it would raise another issue as to whether the parties had the same meaning in the minds when they entered into the settlement agreement, just based on the fact that Mr. Ogden alleged in his complaint that he agreed to settle for a certain amount, which has not been paid out under the settlement agreement. And I think because the Superior Court did not analyze this issue, it did not allow in all the extrinsic evidence and undertake a fair review, the only appropriate outcome at this stage is to reverse and remand. We don't have a full record. We don't have all of the legal issues or the evidence needed to weigh in on this issue.
What other than the email would Mr. Ogden offer to support his contention that the two payments pretty explicitly set forth in the contract were not enough?
Your Honor, I don't personally have materials that are not inside the record. I understand that there's probably more than just that one email, and there may be some other documents as well. I'm not privy to that, but that's again certainly a reason why this case should be reversed and remanded. And moving into the second point, the Superior Court in the second action should not have accepted jurisdiction over this case, because the first issue, whether all matters between the two parties should move on to arbitration, is pending before this same Court of Appeals. And Mr. Ogden faces the possibility of potentially winning his first case where the court decides that the parties have to go to arbitration, but then losing the second case where a court of law has determined as a matter of law he has no claims. This is the type of circumstance that the doctrine of abatement exists to circumvent. The doctrine of abatement is essentially when the first court accepts jurisdiction over a case, it accepts jurisdiction to the exclusion of the second court. And I think clearly the elements here are met. You have the same parties. You have essentially the same action, whether Mr. Ogden has a valid breach of contract claim against Digital Intelligence. It's simply that in the first action, he's requesting this be decided by an arbitrator. In the second conditional action, he's preserving his claim in a court of law. And finally, Your Honor, moving to the issue of attorney's fees, in the settlement agreement, paragraph 6 of the settlement agreement essentially states that each party shall incur its own costs for attorney's fees. And from my review, it's unclear what the Superior Court's reasoning for finding paragraph 6 did not control in this case. The Superior Court may have determined that because Digital Intelligence was not the moving party, this provision didn't apply to it, or perhaps the Superior Court determined that this was a proceeding to enforce this agreement did not cover the current breach of contract matter before the Superior Court. However, it's clear paragraph 6 is not a unilateral fee provision. It uses the term prevailing party when determining like who can recover under paragraph 6, but it also makes very clear that each party shall incur its own costs for attorney's fees.
So under your reading of paragraph 6, the fees, each party incurs his or its own attorney's fees, but all the other costs could be laid on the winning party. Filing costs, deposition, copying.
Yes, Your Honor. Presumably, there's not very many court costs in this matter. It didn't move very far on the merits, but yes, paragraph 6 applies to this case, and so certainly, whichever party prevails would be entitled to court costs and litigation expenses, but each party will not be entitled to their attorney's fees. And turning to the issue of whether this breach of contract matter falls under paragraph 6, as we pointed out in our opening brief, the Arizona Supreme Court in Cameron Brothers Enterprises v. Tonke Verde Plaza has interpreted a similar provision that used this term to enforce the contract, and found that it applied to a breach of contract matter, noting that essentially the plaintiff in that case was moving to enforce its rights under the contract. Certainly that's what Mr. Ogden was attempting to do in this case. He was trying to enforce the full amount of the payment that he was owed under the contract. And clearly paragraph 6 applies in this case, and because paragraph 6 applies, the Arizona attorney fee statute cannot apply. The Arizona Supreme Court in the American Power Products case has made it very clear that the Arizona attorney fee statute cannot operate if it effectively conflicts with the contract, and it certainly does so here. With that, unless there are any further questions, I'll reserve my remaining time.
Thank you. Thank you.
Thank you, Your Honor.
Good morning, may it please the court. My name is Josh Waltman, and I'm with the law firm of Littler Mendelson, and I'm here representing the defendant Disys. Your Honor, I'd like to start by thanking Mr. Lindsay for taking on representation in this case. He's done a fine job, and he's been good to work with throughout this process. So I congratulate him on a job well done and a service to the bar. From our client's perspective, this is a case in which there needs to be certainty in the law and certainty in settlement agreements. We entered into a settlement agreement that very clearly stated the amount to be paid. Part of it was on a 1099, for which the full amount would be paid. Part of it was on a W-2 basis, which gave an amount and said, quote, less requisite payroll deductions, end quote. We made those payments and have since been subject to attempts to initiate arbitration on these same claims and multiple lawsuits on the same claims. We think that it's important to establish some finality when the parties enter into an agreement that is clear on its face. Certainly we've cited the case law saying that when an agreement is clear on its face, the court can decide it as a matter of law. The argument about bringing in extrinsic evidence would only apply if it was susceptible to different interpretations, and our position is that it's not here for the case, and we rely on the case law cited in our briefs. In preparation, I also ran across the ELM Retirement Center case 226 Arizona 287, in which the seller of property said there in the contract there are no representations about square footage, and the buyer must confirm those on their own, on the buyer's own. Sold the property. The buyer then said, boy, you made some verbal statements about square footage. The court did not find we needed to go through a lengthy trial at the Superior Court, but said on its face the contract was clear and that it would enforce that clear language. I don't think that's a new legal proposition we're offering you. That's the same legal proposition we cite in our briefs.
What about the contention that your adversary makes about Mr. Ogden in the trial court saying, I have other evidence. If we are allowed to proceed, I could bring in other evidence to undercut the meaning of the agreement.
I don't think that the general statements like that are enough to create a reasonable understanding that there could be two different interpretations of the contract. The only specific evidence that Mr. Ogden cited to was the email, which is April 5th, and it predates the signatures on the settlement agreement, which are April 26th and May 2nd. I'll note that the settlement agreement, as you saw in the briefs, has an integration clause stating that this is the complete agreement and supersedes any prior discussions. So I don't think that a generic statement of "I can prove my case" is enough to get by this rather strong case law saying if the agreement is clear and it's not susceptible to multiple interpretations, the trial court should be able to dispose of cases like this rather quickly to efficiently proceed through its docket and to give the parties and the public some certainty that when you enter into a settlement agreement with clear terms, that you won't be dragged into effort after effort to compel arbitration, file a first lawsuit, file a second lawsuit.
Is the email in the record? The April 11th email?
You know, Your Honor, I'm remembering it's in paragraph 13 of the complaint, and I'm sorry to say, standing here before you, I can't remember if it was attached to the complaint or not.
We couldn't find it, but it might have been there.
I don't have a reference for it, Your Honor. I'm not aware of it, but I did not specifically look for that before I came today.
Have you seen it?
The email itself? You know, Your Honor, I don't know if I've seen the email through the process. We've been so focused on telling the court, for instance, the first lawsuit said, hey, you need to compel arbitration, and made no mention of the settlement agreement at all. And our client's been asking us to get rid of this case as quickly as we could. In fact, in the first lawsuit, although we could have moved for fees, that's the arbitration agreement, based on contract, we could have moved for fees. We just wanted to be done with this. We didn't want more attempts to arbitrate and more appeals and more lawsuits. And so while we could have asked for fees in the first case, we didn't. I want to make clear we are asking for fees in both cases on the appeal, both in the first lawsuit, which is trying to enforce the arbitration agreement, and the second lawsuit, which turned on the settlement agreement. I'm happy to address more on that if you want, Your Honor. Otherwise, I'll move to the second point that Mr. Lindsay made, which is that the point of abatement. The cases cited in the briefs by the appellant for abatement are distinguishable because they are divorce cases that were filed in two different counties. And they were cases in which one party filed for a divorce in one county and subsequently the other party filed for a divorce in the other county. They're seeking to dissolve a marriage in both cases. And they were filed in two different counties by two different parties. And importantly, the case law says they were both, quote, still alive, end quote, at the same time. Here, our case is quite different. Both cases were filed by Mr. Ogden. They're both filed in the same county. And they were not, quote, still alive before the Superior Court at the same time because the same day that Mr. Ogden appealed the first case, he filed the second case. In addition, we've argued that the abatement argument was waived because Mr. Ogden did not move to consolidate below, and consolidation is discretionary, so that's a different standard of review. We don't believe the court below abused its discretion in failing to sua sponte consolidate two cases that were not even pending before the court at the same time. In addition, Mr. Ogden did file a motion to stay, but he did so late, 8 months after he appealed the first lawsuit and filed the second lawsuit.
Are the abatement issues, in your view, resolved if this court sensibly resolves both the cases?
Your Honor, I think that if Mr. Lindsay's argument, the answer is yes. I don't think the court needs to address that in its order. This second appeal, which is the one captioned 18008 0048 that we're arguing before you, it essentially says, look, I thought I should have had $13,810, but they paid me $126 less. They paid me $13,684. And our explanation is, yes, we paid you the amount in the settlement agreement, which was a set amount for the 1099 and an amount less requisite payroll deductions for the W-2. If the court resolves that to agree with the Superior Court saying as a matter of law we can decide this one, then I don't think the court needs to address the abatement issues, because the argument Mr. Lindsay made is, well, I could lose on the merits on the second case, meaning that I was not paid the full amount, that they fail on that argument, but that the first case could be ordered to arbitration. So I guess actually when I was explaining that to you, I got that reversed. I think it's actually the first lawsuit was correctly decided that it should not go to arbitration. Then you don't need to decide the abatement issue.
Okay, talk to us about attorney's fees.
Yeah, so the attorney's fees out of the three arguments I think is the most interesting, frankly, because we have an attorney's fees provision that's a little hard to read through. The Tanque Verde case is distinguishable because we're all familiar with common attorney's fees clauses that say, look, the prevailing party, and certainly we wouldn't be here arguing to you that a clause like that should be interpreted one-sided. We don't have that clause here. We have a bit of a clunky clause, and I think that the key phrase is the successful, incurred in the successful prosecution. So the clause starts out sounding like it's going to be a typical, prevailing party does not recover attorney's fees, but then it changes course halfway through, and that's what the Superior Court agreed with us on and why it awarded us our fees in the second case below. The clause is in paragraph 6, and it says, the prevailing party in a proceeding to enforce this agreement shall be entitled to recover, in addition to injunctive or any other proper relief, its reasonable and necessary court costs and litigation expenses incurred in the successful prosecution of such litigation. However, each party shall incur its own costs and attorney's fees. Our position is, unlike a traditional, hey, the prevailing party and then either gets or doesn't get the attorney's fees. Our position is this says, look, you have to be the party enforcing the agreement, and these have to be fees expenses incurred in the successful prosecution of that. So we think that this clause is limits the party who brings the case, who succeeds in the case. If it's not that situation, we revert to 12-341 and 341-01.
Because in your view, 12-341-1 would apply if the clause said incurred in the successful prosecution or defense of such litigation.
So in our view, 12-341 and 341-01 are the default. They're the statutory. So can you restate your question?
Yeah, I'm sorry. What I hear Mr. Ogden saying is under the power case, Arizona power case, the statute is the default, and unless the parties have contracted around it. And Mr. Ogden says here in paragraph 6, the parties have contracted around it. What I hear you saying is, well, the contract around is very limited, and why we know the contract applies here applies to or hinges on who brings the action is because of the phrase successful prosecution of such litigation, which in your mind would limit the applicability of paragraph 6 to a situation in which the plaintiff would prevail.
That's correct, Your Honor. So the plaintiff brings the proceeding to enforce the agreement. That's in the first part of the clause. And this clause controls those cost expenses incurred in the successful prosecution. So, yes, the default is 12-341, and unless the parties contracted around it. What we usually have is the parties just simply contract around it. We don't here. We have a more limited situation where the parties have partially contracted around it, and that partial effort doesn't apply here. That's our position.
And in your view, what paragraph 6 would have to say in order for Mr. Ogden's view to carry the day would be have to say litigation expenses incurred in the successful prosecution or defense of such litigation.
That's right. That's one example that could change the outcome here.
But make it even-handed.
Yes, Your Honor.
Yeah. Although what about, under that view, let's play with the text, isn't the clause that follows perhaps independent of the rest? However, each party shall incur its own costs for attorney's fees. That doesn't say that's not limited to a successful party or not, is it?
Your Honor, that's one possible interpretation here, and our position is that this clause with its semicolon is trying to describe a situation in which the party brings a proceeding to enforce the agreement, which Disys did not do, and is incurred in the successful prosecution. That was not the case in Disys's view, that we're not limited because we didn't bring this to enforce the agreement. We're not limited because we didn't incur these efforts in a successful prosecution. Certainly understand your point. Respectfully think that's not as good of reasoning of this particular clause.
I hope this isn't in some Littler Mendelsohn form file.
Your Honor, we did not draft this. Your Honor, I am obviously very happy to go through the factual background. I'm happy to argue any other issues that you have. I feel that our points have been made in the brief, and for that reason, if any of the judges have any questions, I'll be glad to field them.
I think we're good. Thank you.
Thank you so much.
Thanks for your argument. Mr. Lindsay.
Thank you, Your Honor. Just to follow up on the issue that we were just discussing about the attorney's fees provision, I think Your Honor is correct. Clearly, that second portion of the attorney fee provision is independent of the first. It clearly states each party shall incur its own attorney's fees, regardless of who the prevailing party is for the litigation. But I would also argue that the successful prosecution terminology right there, I don't, it's a bit of an odd reading, but I think that the key term in that clause is prevailing party. And that's a common phrase that attorneys are familiar with. And it applies to whoever prevails on an action that is seeking to enforce the agreement. It could be the plaintiff, it could be the defendant. It could apply to either party. But regardless, clearly the second portion of paragraph 6 applies. And, Your Honor, I'm only familiar with two limited circumstances where the attorney fee statute can apply even though the parties have contracted for recovery of attorney's fees or to not allow the recovery of attorney's fees. The first would be if the parties had a unilateral fee provision, and then in that instance, a court could look to the attorney fee statute, and if it's not contrary to what the parties contracted for, it could then award attorney's fees under the attorney fee statute to the party that is not otherwise contemplated in the contract.
What would that clause look like? I get fees and you don't?
Essentially, yes. It would specifically say the name of a party can recover its attorney's fees against the name of the other party. In that instance, a court can look to the attorney fee statute and award attorney's fees to that other party that otherwise is not provided for in the contract. The second instance would be if the attorney fee clause in the settlement agreement or in any sort of contract uses the term prevailing party, does not define that term, and relies on Arizona law, courts can look to how prevailing party is interpreted or defined in the attorney fee statute, which is the situation that happened in the American Power Products case. The court found that second sentence in the attorney fee statute could operate, where prevailing party could be someone who submitted an offer of judgment and then beat that offer of judgment. They could then be defined as the prevailing party under the attorney fee statute. Neither of those situations exist in this case. To quickly address some of the other arguments, with respect to the issue of abatement, I just wanted to quickly point out the Allen v. Superior Court case, which is cited in the brief, does deal with the situation where there were three actions filed in divorce proceedings. Two were filed in different counties, but there were two actions pending in the same Maricopa County Superior Court county, and the Arizona Supreme Court found that even those actions abated. So the issue of abatement still applies even if two actions are pending in the same county.
Is the harm to be avoided in abatement that a party will be deprived of his day in court?
I would argue the harm to be avoided is inconsistent relief.
Okay.
That allowing a second court to infringe upon the jurisdiction of the first court and award contrary relief to one party. And Your Honor, again, with respect to how much is at stake in this breach of contract matter, I know Digital Intelligence has argued that it's a difference of $126. I'll simply note that in Mr. Ogden's complaint, he alleges that it's more than that amount, and you know it may not seem like a lot of money, but this is something that the parties agreed to settle for, and it is certainly important to the parties. It is certainly important to Mr. Ogden.
Thank you.
And with that, Your Honor, I appreciate the court's time, and thank you.
All right. Thank you to both sides for your argument. We'll take the matter under advisement and issue a decision in due course. Now we will adjourn.